Good morning and welcome to the closing session of the ID&R Forum. My name is Celeste Rodriguez-Jensen and I have my colleague with me, Sarah Martinez. We are really disappointed that we can't be there with you in person, but delighted that we can still be a part of the presentation this morning. We really want to thank you all for being a part of the ID&R Forum and coordinating and getting to know your peers in other states and regions. And we hope to support you guys today with some questions about ID&R and eligibility, and to talk a little bit about what processes and tips you guys can use in making tough eligibility determinations at your local, regional, and state level. And so before we get started, we're going to give you a little bit of an introduction, so I'll go ahead and start. So I'm originally from Austin, Texas, where I went to St. Edward's, which is home to one of our oldest camp programs. From there, I went on to teach 7th and 8th graders reading and language arts, which I had the privilege of teaching some of our migrant students. And then I had the fortune to move to OME, where I am a program officer for 12 states. I also work on some of our contracts, including our results.ed.gov website. I also plan and coordinate the annual directors meeting and then support ID&R practices, including the ID&R curriculum and ID&R manual, which again you can find on our results website. And collaboratively, I work with Sarah and some of the other program officers to make sure that the technical assistance we're providing you is the best it can be. So, Sarah, you want to give a little introduction?
Good morning, everyone. My name is Sarah Martinez, and I'm originally from California. I was born and raised there, but I've been on the East Coast for about 10 years now, and 5 of those years have been here in Washington, D.C. And before I came to OME, my background was primarily in education research, and I also worked with a couple of supplemental education services. I ran a lunchtime reading and mentoring program in DC public schools, as well as designed an after-school program for low-income housing community centers. Once I came to OME, this was about 3 years ago, I began as a program officer, and I'm currently a program officer for 9 states. As well as I am a member of the policy team for the office, and I'm also responsible for resolving audits and complaints that come into the office. And it's my experience with the policy team that really informs our talk today. We get a lot of eligibility questions and a lot of questions about ID&R practices, and we're actually going to go over a few of those recent examples with you and sort of talk you through the process. So with that, I'll turn it back to Celeste, and she's going to start talking us through the process of how, when you encounter some of those tough eligibility questions, the process that you want to go through step by step.
So we're going to start from the very beginning. You may hear from a recruiter or your regional director concerning a particular eligibility determination. And before you can really get started, you want to make sure that you have all the basics. And when I mean basics, I'm referring to the 5 eligibility factors. So age, school completion, move, the purpose of the move, and then the qualifying work, whether it be seasonal or temporary. It's going to be really hard to provide your recruiter a full and complete answer without this information. So you'll get started with the basic information, and then from there move on to the statute and regulations to look through if there's anything that you can find that will specifically speak to your question. And if it's coming to you, it is likely not going to be word for word in the law or the regulations. And so from there, you want to move on into your state's guidance, OME guidance, and then anywhere else you might be able to find some policy questions and answers where, this question might have been addressed in the past. That could include our website, where we do answer questions quarterly, which we'll be going over a little bit later in this presentation. But likely, you're not going to find a word-for-word answer that matches your situation. And so from there, you're going to need to dig a little deeper. And Sarah's going to speak to that phase of deliberation.
That's right. So once you've collected all of the basic information that you need and you've done some of that preliminary research, if you still haven't arrived at an answer to your question, the next step would be to think about some of those questions that we have answered before, that your state has answered before, and determine whether any of those are similar enough to the scenario that you're considering to be able to apply the same logic to your question. Oftentimes that works, sometimes it doesn't. So the next step you would take is to reach out to your network. We encourage you to talk to your fellow recruiters within the region, talk to the regional MEP staff. If you don't find the answers that you're looking for at the local level, the next step would be to go up to the state level, reach out to your state MEP director, and get their feedback on your particular scenario. You can also, we encourage you to reach out to other state staff. We're always encouraging our MEP staff to collaborate with one another, both within the state and across states. So speak to some of those other recruiters and see whether they've encountered similar circumstances and what eligibility determination they made in those cases. Once you arrive at a decision that you're fairly comfortable with, you want to take a step back to the guidance, the statute and the regulations, and think about whether your determination is in line with what's in the statute and the regulations, just to make sure there's nothing that conflicts with what's in the law. And then finally, this is the final step that we do as part of the policy team, is we take a step back from that particular scenario and think about the bigger picture. So think about if your eligibility determination for this particular family or this particular child, if it were applied statewide or even nationwide, what the implications of that would be. So once you've gone through all of those steps and you're comfortable and confident about your decision, the next step would be to write up your eligibility determination. And for that process, there's a couple of steps to think about as far as supporting your decision and also being able to explain it to anyone else. So Celeste is going to go over a few of those pointers for you as well.
And this is where we kind of go back to the basics. You want to make sure that in your written documentation to the recruiter, and then which you will likely send out to other recruiters or other locals or regions, the basic facts and any assumptions they might need to know. So specifically, you'll let them know the 5 eligibility factors and then any other pertinent information. And then from there, you want to make sure that you're providing the most current and accurate reference to the statute and regulations and guidance, so that as a reader's reading through your written response, they can go back and find the answers for themselves. And in a way, you're also empowering your recruiters to make sure that they know the laws and rules well. And then once you've provided the statute, regulations, and guidance references, you want to provide a statement or two explaining how you use that information to make your determination. And then lastly, you may want to include an additional example so that it's clear to the recruiter how this might play out in another situation. And as Sarah mentioned before, a lot of our tips come from the policy procedures we use in our office. And so for those of you that have received a letter from us in the past answering a policy questions, these are our general rules and guidelines that we follow every single time. And so we hope that they are as helpful to you as we have found them to be for us. And so from here, we're going to move on to some of the questions that states have provided to us in the past, and then a few questions and answers that we thought were going to be most helpful for you all. And so we'll get started.
Okay, so we selected about 6 questions as examples for you all, and we wanted a little bit of variety, but the first couple of questions concern eligibility and specifically qualifying work. The next questions that we'll talk about are more about qualifying moves, and then finally we'll wrap up with 2 questions concerning ID&R practices. So for the first eligibility question, this concerns work on horse farms. And this is really a 2-part question. The basic question is whether work on horse farms qualifies for purposes of the map. And the follow-up, or second part of the question is, if this work does not qualify for the program, this particular individual wanted to know why. And this individual was thinking that the work on horse farms does not qualify because we do not grow or eat horses in the same way that we do cows or other agricultural products. So I think Celeste will talk about basically whether the work qualifies and then our rationale, or the program's rationale for why it does or does not qualify.
So I'm actually going to start with the second question first, in that why may a horse farm not qualify as qualifying work. And so we want to go back to those basic eligibility factors, and whether a worker produces a product for human consumption is not one of our factors. And so that is not something we take into account when determining whether or not a particular activity will qualify as qualifying work. Now, we do take into account for qualifying work temporary or seasonal employment, and to make sure that it's in agricultural work. Agricultural work is defined by the product or initial processing of crops, dairy products, poultry, or livestock. And so getting into specifically when a horse farm may be a qualifying activity, we need to look at what activities are taking place on that horse farm. For example, if the horses are produced or kept primarily for breeding or slaughtering purposes, this would be a qualifying activity under the MEP. For example, the horse work with the horses intended for slaughter would be considered the production of livestock. And then similarly, if some of those horses were used to care for livestock, such as cattle, we would consider them an integral part of the agricultural work and the production of cattle on that farm. In a situation where a horse farm would be ineligible for the MEP is if the animals were being used primarily for recreation, sports, research, or pets. These horses would not be considered livestock for purposes of the MEP, nor would they be integral to the production of other livestock, such as cattle. And so consequently, it would not meet the definition of agricultural work. But as we go through some of these other determinations, it is important to look at the specific situation and the facts surrounding the particular activity. So we're going to move on to another question about qualifying work. And in this scenario, we were asked about whether bee tending is considered qualifying work for the purposes of the MEP. And that can usually include a lot of different activities. I think Sarah's going to speak to some of those.
So when we think about bee tending or beekeeping, we look at some of the specific activities that are involved with that. And some of those activities include keeping the bees alive, pollinating the bees, splitting the bees into additional colonies. Those activities are all integral to producing crops such as honey or beeswax, or even pollinating fruit or vegetable crops. So for those reasons, we do consider this type of work to be in line with our definition of agricultural work. Now that's just about the work itself. You of course also have to look at other factors surrounding the work. So if, for example, the work is being performed for recreational purposes, that would mean that the work is not qualifying for purposes of our program. Or another example of where beekeeping might not qualify is if the people or individual performing the work is doing it on a permanent basis, or if they own the bee farm. In that case, they would not be performing the work on a seasonal or temporary basis, and so they would not qualify for purposes of the program. But strictly looking at the work itself, those activities do qualify as agricultural work for purposes of our program. Okay, and now we're going to move on to a couple of other eligibility questions, and these surround the circumstances of the move itself, as opposed to the type of work being performed. So in this scenario that we received, 2 school-aged children moved with their aunt from their father's residence in Oregon to their grandparents' residence in Washington. The children stayed with their aunt and grandparents for 2 weeks. The grandparents then took the children back to their father in Oregon. The grandparents sought and obtained work in Oregon. So the question is, can the children qualify under the grandparents' move to Oregon?
So there's a couple of aspects to answering this question, but let me start off by saying that based on the facts provided to us by Sarah, our determination is that these children do not qualify for the MEP based on their move with their grandparents. The child's separation from their father was such a short duration that he likely retained his guardianship of his children, and thus the grandparents were not acting as temporary guardians of their grandchildren, and also the fact that they merely stayed with their grandparents for that said 2 weeks duration wasn't a change of residence due to economic necessity. It was more akin to a family visit or a short vacation. As you know, there are several factors that children need to meet to be eligible for the MEP, and it's important to look at each one of those individually as you're trying to make those determinations. And so, I mentioned just briefly about the short time they spent with their grandparents, and our next question is specific about short duration moves and whether or not is there a specific amount of time that a family should be gone in order for a move to constitute a change of residence.
Okay, so the simple answer to that question is OME does not recommend a specific amount of time that a family must be gone in order for the move to constitute a change in residence. What we do define in the regulations is what constitutes a move, and those are pretty basic factors in that the family needed to change residence, and there's also a factor regarding a change in school districts, crossing school district boundaries. And there are a couple of exceptions to the school district boundary rule, and that's for a couple of our states with Hawaii and Alaska. But generally, in order to be considered a qualifying move, they have to change residence and cross those school district boundaries. The reason that we don't specify a length of time for that move is that it varies so much from individual cases that we think this is a decision that's best left to states. So there are so many factors that surround a family's move that we think recruiters really need to consider the context and then make that decision whether there was a change in residence or not. So to give you a couple of examples, something that we would consider a change in residence and we would consider a move for purposes of our program would be if a worker moved from Louisiana to Ohio and with the purpose of performing seasonal agricultural work. But once the worker arrived in Ohio, he found that there was no work available. He spent a total of 5 days in Ohio searching for work. He was unable to find work, and so he returned to Louisiana. So in that case, it's a very short duration that he was away, 5 days. But the reason that we would consider this to be a move for purposes of our program is that the worker moved with the intention of obtaining qualifying work. And he did intend to change residences, even though he was unable to stay in Ohio for a longer amount of time. So in contrast to that, an even longer move that we would, or a longer time away from residence is one that we would not consider qualifying for purposes of our program, would be families that are able to go to Mexico for 4 weeks, say over the holiday season. They might consider Mexico to be where they might not consider Mexico to be where they live, and simply where they're visiting for the holidays. So in that case, even though it's a longer amount of time that they're away, 4 weeks, we would not consider that to be a move because that family considers their residence to be in the U.S. So again, it varies so much on a case-by-case basis that we think that duration is a rule that's best left to states to decide. So now we're going to move on to a couple of questions that concern identification and recruitment practices. And the first one is one that we've seen increasingly as states move to the electronic COE. We got a lot of questions surrounding the use of the electronic COE. We know states want to make sure that they're adhering to all of the statute and regulations. And this particular scenario was concerned with, in cases of an audit, whether the signature on a COE, whether an electronic signature would suffice, or whether the recruiter would need to print out a paper copy and have the parent or guardian sign that paper copy.
Yeah, so as Sarah mentioned, this has become a more common question as more states move to electronic COE. So if your state is currently using electronic COE or is looking into it, the first step you want to make sure is that you are checking with your state auditors about the use of the electronic signature. After consulting with our program attorneys, we do find that an electronic signature should be sufficient for audit purposes, provided that the state has adopted and implemented written procedures which make it clear that the SEA will rely on the electronic signatures to identify the individual to sign the documents. We believe that this would be sufficient for auditors because they'll be able to still facilitate an effective audit, and they'll still be able to, and the state will still be able to maintain records that are compliant with our program requirements. Now, as a best practice, we do advise that SEAs within the written procedures should include provisions about making copies available of the electronic documents to the individuals that are signing the documents. And so again, when you're looking through making changes or new processes in your state, starting with your state procedures first to make sure that you're covering your ground there, and then, as we go through our questions, making sure the state knows that we are available to answer questions as well once you feel that it's time to include OME in your process. And I believe we just have one more question left about identification and recruitment. And this one speaks specifically about guidance in situations where MET personnel can't verify employment of individuals, specifically about qualifying for the program. So this question is whether recruiters should collect information from workers, such as a social security number, in order to verify their employment. I think we actually have had this question a few times, or some different iterations, but Sarah will speak a little bit to collecting additional documentation about qualifying work.
That's right. So first of all, we do want recruiters and anyone that's involved with certifying that COE to feel really confident about the eligibility determination that you're making. So with that said, we want you to gather all the relevant information that you need to make that eligibility determination. At the same time, the program does not require employment verification. This has never been a policy of ours, and really we know that recruiters are relying primarily on that interview with the family to collect all of that information. So we do not encourage states to engage in employment verification as a routine practice. At the same time, we do understand that there are certain cases where a recruiter may have reason to doubt what the worker says about why they moved for qualifying work or what type of work they're engaged in. So in those limited circumstances, we can offer a few alternatives that are preferable to the collection of documentation such as a social security number. So a few alternatives that you might consider are to ask to see a pay stub or some sort of employment contract. And you might also visit the work site and observe the worker firsthand. So some of these alternatives allow you to collect the information that you need to make your decision, but at the same time, you avoid collecting unnecessary documentation. And the reason we discourage this practice is because, first of all, it's overly burdensome on MEP staff. And second of all, we consider something like a social security number to be personally identifiable information. And with the case of that type of information, the burden is on the state MEP to protect that information. So by exploring some of those alternative ways of verifying employment, you basically avoid the whole burden of protecting the information and collecting documentation. So I believe that was our last question, and we're going to wrap up today's presentation. I just want to thank you all for being here this morning. We really appreciate your participation, particularly given the kind of unconventional format of our presentation. But we do appreciate your participation, and we wish you a wonderful time in Tampa and an enjoyable conference. So thank you.
Thank you.